how to keep your pot of gold, how to protect your assets. A topic that we have covered before in different ways. We're going to be talking, though, today about a little bit of a different perspective. We're going to be focusing on 3 different risks that are out there that can negatively impact your assets for yourself and your family. And it's important that these issues are addressed and these issues are known. So again, thank you for joining us. The intention of our Wednesday webinars is, and we've been doing these, my gosh, it's been 11 months. We started the first week of April, once the unfortunate pandemic began, and we've been doing them every month since. And the hope and the purpose is that we can help educate people and share relevant knowledge to issues that you're dealing with in your own life or with your loved ones. And the goal is to just be 30, 40 minutes, and it's a burst of information. We do have on our website all of the prior webinars, at least most of all the prior webinars for the last year. TullyElderLaw.com, go under the navigation bar for videos and click on webinars, and you can see all the prior topics that we've done, all right? So let's get started. So of course, the primary concern is going to be, how do we protect our assets? That's why we're here. But also there's always, at least in our book, there's always an underlying issue. And that is, how do we protect the people inside the home, right? So protecting the house is one of the biggest things that we do. And it's not just about the house. It's about mom and dad. It's about your spouse. It's about your grandparents. So that's why we do what we do. It's not just about the money. So what exactly are the risks? And you'll see our little leprechaun friend here running away with the dough. What we're talking about today is long-term care as a significant major risk. We'll be talking a little bit about guardianship. It's been on people's minds these days, especially ever since the Britney Spears topic came out. I was interviewed for a piece on Market Watch, one of those news websites, and it's a very interesting topic. Of course, adult guardianship is very different than the type of guardianship that, or conservatorship that Brittany is enduring. But the reality is that guardianship is a reality for folks that do not plan in advance and do not protect their assets in advance. So I'll address it today. And finally, we'll be talking about the risk of probate itself. Okay. Now, why, to talk about long-term care first, why is that a risk? I'll give you the mile-high overview. So as we get older, we can have different things happen to us. We can have different needs, different issues that require attention. If we have to go to a doctor or a hospital or an ER, rehabilitation center, those are medical needs. Those are medical issues. And therefore, our health insurance is going to be paying the bill, or at least hopefully paying the bill, or at least paying the bulk of the bill. If you're 65 and over, it's going to be Medicare. So again, medical needs have medical insurance, okay? Now, on the other side of that same exact coin, you can have what are called long-term care needs. They're not, by definition, medical at all. They are going to be those needs that are functional, best defined by the activities of daily living. For example, transferring, literally getting up and out of a chair or getting up and out of your bed, walking, bathing, toileting, dressing, eating, literally everything you did this morning. That is a functional need. That is an activity of daily living. So when somebody needs assistance with that, such as an aide to come into the house to assist, or even a nursing home as an extreme example, that is long-term care. And why is it a risk? Well, it is a risk because it's very, very expensive. There are 3 ways to pay for long-term care help. The first one is to use your own private funds. Sounds easy enough, but it is actually very difficult to do, and most folks end up not wanting to do it. There's different ways to pay with your own funds. Generally speaking, hiring an agency is the cleanest, most safest way to do it. You're looking at $25 to $30 an hour approximately. That can translate to $300-400 a day, which could be $8,000, $9,000, $10,000, $11,000 a month for home care. So paying for long-term care privately at home can be very, very expensive. Again, the other end of the spectrum is the nursing home. You're looking at an average of $15,000 to $20,000 per month in the New York and Long Island area. Now, some families may have to pay that for a little while, but a lot of families cannot pay that for a long while. It's just too damaging to the surviving family, to the remaining family, paying bills, repairing roofs, tuition, living expenses. It's just not how it was intended. Now, gratefully, New York does have a long-term care Medicaid program to help pay for long-term care. However, in order to get them involved, in order for them to get them to pay for the care, you must be eligible for Medicaid. And that's why this is a risk. You cannot just go to the Medicaid office or to your elder law attorney on the corner and sign up for Medicaid. There is a long, delayed, drawn out process, even when you're eligible. Now, the ideal situation is that people plan and protect in advance of needing the actual Medicaid services to pay for the care in the house or the care in the nursing home. Again, the key word there is advance. You want to plan and protect in advance, and we'll be talking about how to do that today. But it's essential. All right. Now, Medicaid eligibility itself. It is about your assets. It is about your income, and it is also about your care level. So every applicant for Medicaid, whether it's going to be the home care program or the nursing home care program, must demonstrate eligibility asset-wise, income-wise, and care level-wise, okay? Again, it is definitely not a walk in the park. I typically tell clients it's a bear. It is a difficult process made easier by planning and protecting in advance. Now, there are major changes occurring on the home care front, not touching nursing home. The biggest change that is occurring has to do with what's called a look-back period. A nursing home eligibility factor is a 5-year look-back period, meaning you have to do your asset protection at least 5 years in advance of trying to become eligible for nursing home Medicaid. Now, home care, on the other hand, has never had a look-back period, but the governor signed a law last year, almost 12 months ago, implementing a 30-month look-back period for home care. We used to literally be able to shelter and protect, a couple $100,000, a house in March and apply for community Medicaid in April. That's what's going away. The question is, when is it going away? It was supposed to go away in October, then postponed to January, then postponed to 3 weeks from now in April. There is very solid information that it is going to be postponed once and probably the final time to July 1st. We do have a webinar or two on this topic on the Tully Elder Law website, tullyelderlaw.com. Again, click on videos and webinars, or be sure to keep an eye on your email, because in 2 weeks on March 24th, I'm going to be giving another live Wednesday webinar on a Medicaid update. All right. So that will have the most hopeful, we'll definitely have the most current information, but hopefully we'll have confirmation on that April to July postponement. And I'll get into more of the eligibility issues for assets, income, and care. All right. So join me in 2 weeks for that Wednesday webinar. Medicaid is the payer of long-term care for the middle class. So that is certainly something that you need to keep an eye on, and it is the way to shelter your assets, all right, the way to not use your personal assets to pay for all of your long-term care needs. The next risk is guardianship. Now, a guardianship proceeding, gratefully, they are not that common. They happen every day. I've got colleagues that specialize in guardianships, that specialize in contested guardianships, where children and spouses are fighting in the courts. It's something, very honestly, and I'm sure you get this by what I just said, it's something you want your family to avoid. But what exactly is a guardianship? Well, it is an adversarial court proceeding where a interested party, perhaps a spouse or a child, determines that what's called an AIP, an alleged incapacitated person, is in jeopardy of harming themselves financially or personally. Now, that typically means there's a loss of capacity. And what that would also mean is that there is a loss of capacity and there is no alternative way to help this person, meaning that there is no power of attorney, or the power of attorney exists, but it is insufficient. We see both of those cases quite often. I will talk more about the power of attorney because that's one of the tools to implement. But if there is no power of attorney, or the power of attorney is not sufficient, and there is a loss of capacity, and if your loved one is in jeopardy of harming themselves financially or in jeopardy of harming themselves personally, health-wise, then a guardianship is the probable answer. And again, it's a court proceeding and it's deemed to be adversarial, although it's not, it should be handled in the most respectful, diligent way possible. It's where the pursuit is to determine the AIP, the alleged incapacitated person, as incompetent. And the judge would have to do that. As I said, it's about person or property. If there's a need only to help with finances, then the judge will not deal with the personal issues, the healthcare issues. If it's just about healthcare issues, which doesn't happen as much, then they won't deal with the property issues, okay? It can be very expensive. So I'm going to talk about these next two together. There's an attorney for the petitioner. That's the interested person who is petitioning the court. There can be an attorney for a sibling who is contesting. That's two attorneys. The judge will appoint what's called a court evaluator. Again, a third attorney to interview the AIP and determine what's going on and make recommendations to the judge. And if there is any concern on the judge's part, they can appoint an actual attorney for the AIP, the alleged incapacitated person, making 4 attorneys, all billing and charging hourly. This guardianship proceeding, especially a contested guardianship proceeding, can be very, very expensive, and gratefully, it can be easily avoided. And I'll talk about that again in a moment. In addition, there is a tremendous amount of time that it takes. 6, 7, 8 months is fast, all right? If it's contested, you could be looking at a year or more. You want to avoid a guardianship. It is a risk to assets. It is a risk to your independence, to your sovereignty as far as making your own decisions. So you want to deal with this, again, by planning and protecting in advance. All right, now the third and final risk that we're going to be talking about today is the probate proceeding. Less teeth, if you will, than the guardianship proceeding or long-term care, because it happens quite often, this probate proceeding, but it's something you want to avoid. Now, when does it happen? So if somebody passes on with assets in their name alone, okay, assets in their name solely, then that is where somebody has to petition the court, just like the guardianship, petition the court to be named executor if there is a will, or named administrator if there is no will. And that person is saying, hey, judge, I need to be able to have authority over this person's estate because there are assets, accounts, real estate in that person's name alone, and we need to marshal those assets into the estate. We need to pay some creditors, and then we need to distribute the money to the family, all right? Or the heirs, or what we call distributees. So I'll get into that now. Just like a guardianship, a probate proceeding causes delays. And by the way, with all this said, you want to avoid not only a guardianship, you want to avoid probate, okay? Now, the ways you avoid probate, to kind of jump to that for a brief moment, if you cause probate by having assets in your name alone, then the opposite is true. You can avoid probate by having accounts that are joint with people you trust. You can avoid probate by having beneficiaries on your accounts, like life insurance, annuities, or IRAs. Or finally, you can avoid probate by having your assets owned by a trust, which, surprise, I'll be talking about that momentarily, okay? So again, probate is to be avoided because of time delays. It is to be skipped. It is to be avoided because of the costs. There's attorney fees that can escalate, and there are court filing fees. So you also want to avoid those. Another reason to avoid probate, it is a fully public proceeding, meaning that the petition for probate or the petition for letters of administration, if there is no will list the decedent's information, the address, the family, the approximate assets, all out there in public domain. And there are literally companies there to harvest that data. In this day and age, identity theft, fraud, etc., another very, very important reason to avoid probate, okay, is that loss of privacy. You want to keep privacy. And the way you would do that is by avoiding probate through joint accounts, beneficiary accounts, and trusts. Now, another real practical problem we run into with probate, especially if it's not a simple family structure, are what we call distributees. That's what the law calls the heirs, the next of kin. So if there's 3 kids, all 3 kids are alive and all 3 kids are healthy, meaning not disabled, then it'll be pretty straightforward as long as they all cooperate. If there is a disabled child, there is going to be a guardian ad litem appointed. If there is a minor child, there's going to be another guardian ad litem appointed. If there is missing heirs that are being disinherited or can't be located, or if there are no direct children, then you got to find people. Right now, we're working on an estate for the 3rd year, finding folks, and it's appropriate for our topic today, in Ireland. Sweet Irish couple in Queens, no children. All right. We were able to help with the vast majority of assets, but there's one asset out there that the Queen's Surrogates Court is requiring us to perform extreme due diligence in Ireland, as well as the States, to find other heirs so that that will can be admitted to probate. You want to avoid that. In addition, if you have, if you are disinheriting a child or doing different percentages for your children, the probate proceeding gives that grieved child the ability to actually contest. They get called into court and said, tell us why this will should not be admitted to probate. Tell us why your brother shouldn't be executor. All of those potential risks will delay the process incredibly if they happen to you, all right? Next. If you have real estate outside of New York, it's good to know that you're going to have to do a probate in that other state as well. This doesn't apply to financial accounts, it's just real estate. Everywhere you have real estate, you have to have some type of a court proceeding. Another reason to avoid probate. We had a pandemic, didn't we? We're still in it. The courts literally shut down for 4 months, and we're still dealing with the delays and the backlog from back in April when they shut down. So if your family was in the middle of an estate proceeding, it got put on hold. And if they were fortunate enough to be at the top of the pile, then it's been picked up slowly. New estates that are being filed, again, they can be subject to the backlog. So you don't want that happening to you or your family. Now, two further legitimate risks as to why you should avoid probate, and they both involve Medicaid. So Medicaid it can be a blessing and Medicaid can be a curse. Medicaid, again, is that program that can come in to pay for the long-term care as long as you're eligible. If a person is on Medicaid and they have assets in their name alone, we know what that means. It means probate. If you file an estate proceeding, a probate proceeding for a person that was on Medicaid because they have an account in their name alone, bingo, the next one is popping up. It's called estate recovery. Medicaid is a party to that action and they will take that account. Okay. So avoiding Medicaid estate recovery is a very valid reason to avoid probate. The other one I clicked on there is right of election. Harder to avoid. It's where you have one spouse on Medicaid and the other spouse, unfortunately, passes on first. Now, that other spouse may have assets in trust for the children or may have given property to the children, but that what we call well spouse would be intentionally disinheriting the Medicaid spouse. I touched upon this issue in our last webinar 2 weeks ago. If you want to talk or learn more about that, again, go to the website for that. So if a well spouse passes on before the Medicaid spouse, then there is a right where Medicaid can literally step in the shoes of the Medicaid recipient and demand 1/3 of the deceased spouse's estate. Again, it's harder to avoid this, but it is a reality when you're dealing with probate and administration proceedings, okay? Planning and protecting in advance can help minimize this, all right? Now, how do we do that? Well, here we go. Typically with a trust. Okay. Now, the good news is a trust is not a very, very complicated process. I will be the first to admit, I started practicing in 1998, so it's been over 23 years I've been doing this. When I first was getting out of law school in 97, um, the idea of a trust, especially what's called an irrevocable trust, was intimidating. I was able to work with a mentor that I trusted, and he was able to teach me and show me the ropes, and they're really not that complicated. They sound complicated until you know what they are. And all a trust is simply a written document. That's it. It is a written document that says, okay, trustee, whoever that may be, you're going to hold these assets for me and you're going to use them for my benefit. And you're going to manage them this way while I am alive and healthy. And then you're also going to manage them and handle them if I'm alive, but not so healthy. And finally, the agreement is going to say, when I'm gone, this is who you're going to distribute the assets to. That's what a trust is. Of course, there's more articles. Of course, they could be 40 pages long, but that is it in a nutshell. All right. You're giving your assets in a written agreement to a trustee for your benefit during your life and at your passing. All right. Now, every trust has to have four parts, okay? It has to have a grantor. Maybe that's our leprechaun guy there. So the grantor is the one that is creating the trust, the one granting the trust, okay? The trustee is the second person that's required, and that is really the manager, okay? Now, in the different types of trusts, the trustee may have to be a child or a relative, but in what's called a revocable trust, then the grantor is the trustee themselves, okay? The revocable trust, as I'll talk about in a moment, is not an asset protection tool. It is there for asset management and probate avoidance, okay? So the trustee in a revocable trust scenario is going to be the grantor as well, not in the irrevocable scenario. The third person that's involved is what's called the beneficiary. There can be different types of beneficiaries. There can be lifetime beneficiaries. There can be what's called a death beneficiary. There can be a beneficiary as to any income generated in the trust, and there can be a beneficiary as to the principal, which is the assets within the trust, okay? You have to have that built into the agreement. And finally, the trust has to own something. If you've ever seen a trust, there's typically a Schedule A on the back, which is an informal inventory. And sometimes you just see $10 cash. That is the symbolic funding of the trust because there has to be something that is bound or being held by the agreement, okay? Now, next part. As I was saying, there's two types of trusts. The first one is what's called revocable, and the second one is what's called irrevocable. The revocable trust is the one that is for asset management and probate avoidance. It is a revocable trust, meaning I can set it up. I am the grantor. I am the trustee manager. I am the full beneficiary. I can do anything I want with that money. I can set the trust up on a Monday. I can put money in. I can take it out on a Tuesday. I can amend it on a Wednesday. I can revoke the whole darn thing on a Thursday. It's revocable. It's my entity. Now, the irrevocable trust is very different. It has a different purpose. Yes, it avoids probate, but it is there for asset protection purposes. Therefore, there needs to be a wall primarily between the assets that are being protected and the grantor, okay? So the purpose of asset protection means it's going to have some restrictions. However, and remarkably, there is a solid, good amount of control and flexibility built within an irrevocable trust that it's almost like there isn't one, all right? So if you want to learn more about that, of course, we can talk about it. I'd be happy to do that. We do Zoom, we do phone, we do in-person consults safely. Or again, you can check one of our prior webinars. Now, let me summarize the two trusts. Again, two types of trusts, revocable and irrevocable. Now, there's two primary reasons why people do trusts. The first one, forgive me, the first one is to avoid probate, and the second one is to protect your assets. All right, two types of trusts, two reasons people do it. When you have a revocable trust, yes, it avoids probate. That's what it's about. The irrevocable trust, Yes, that also avoids probate because it owns different assets, right? And when you have an ownership and a beneficiary listed in the trust, you don't need the court to help. Now, asset protection, as I've mentioned, the irrevocable trust, yes, asset protection, that's primarily what it's for. However, asset protection does not, repeat, does not exist with the revocable trust, okay? So when we talk about protecting your pot of gold, it is the irrevocable trust that's the answer. Now, let's talk about this a little bit, all right? I'm going to pick it up a little bit, but let's talk about how these things operate. The purpose of an irrevocable trust, we know that, is to protect assets. Why? Because if we need that long-term care Medicaid program down the road, then we can get those assets out of our name in advance before those look-back periods begin, okay? The purpose of the trust is to move assets out of your name so that you could get the look-back period started, all right? And then go live your life, those 30 months or 60 months, which I'll talk about. And then after that period, if you need Medicaid for long-term care, the assets are protected. So this is all about timing. Now, as I was sharing a moment ago, in order for an irrevocable trust to actually protect your assets, those assets within the trust cannot directly be distributed or transferred back to the grantors. That is the wall I was talking about, okay? You have to build a wall. We build a wall in our trusts between the assets and the grantors, okay? Now, the concept is this. If you had a trust where you had full access to the money in the trust, for example, if you could say, hey, trustee, give me $10,000, or if I had the access to go in and pull money out of the trust, then you know what? If I have access, then so does Medicaid. If I have access, then so does the government. So does New York State, New York City, Suffolk County, Nassau County. If I have access, then so does my creditors, okay? So this is a required rule. Now, you never, ever put all of your assets into an irrevocable trust, okay? You always leave your retirement accounts out. You always leave enough money out to live off of. Vacations, the hole in the roof, the new oil burner, you always leave money out of the trust to live off of. And that is a discussion that happens between us and our clients all the time. How is the trust funded? So that's something that has to be dealt with, okay? And this is not as insurmountable as you think. Income. As I said, you could have different income beneficiaries. With this type of a trust, you do earn any net income that is generated within the trust. If you put your home in the trust, and that is an ideal asset for this type of a vehicle, 100% you've got the legal right to live in the house. As I tell people every day, nobody can kick you out. Nobody can make you pay rent. The place is yours, okay? Because of that right to live, more good news, more control, the real estate tax exemptions remain, okay? So you are not going to lose your STAR exemption. You're not going to lose your veterans exemption or your senior citizens exemption. You keep those exemptions in place even though your trust owns your home. You have the ability to sell your house, okay? You can decide in 2 years, all right, trustee, sell my house. The house leaves the trust, the cash goes into the trust. Good news, all still protected as of 2021. It is not, repeat, it is not a new 5-year window at all. And then that trustee can go buy another property for you, okay? Still all protected. More control and flexibility. Let's say you pick your middle child as your trustee. Happens. My parents did that. They picked me. So if you pick your middle child as a trustee, then if God forbid there's a falling out, let's say she just says, ups and leaves the New York area, heads out to Vegas, you don't hear from her anymore, you don't see the grandkids, it's not a good situation. You are not required to keep her as a trustee. You can fire her as a trustee. You can remove her as a trustee, okay? And then the next one steps up, or you can pick somebody outside the family. Same thing with beneficiaries. Back when I first started doing this type of work, clients would say, I don't want an irrevocable trust because then I'm locked in as to who inherits. Absolutely not. You are able to change your beneficiaries. So if you've got your 3 kids as beneficiaries, but in a couple of years you realize those grandkids are the best, I want to give them a piece, you can do that. All right, you keep that control. In addition, we always recommend what's called a trust protector. A trust protector is somebody outside the family that can actually amend the trust to keep it valid within New York law or to make it valid in another state. Okay, so this is how you can actually amend the irrevocable trust. Taxes. This type of a trust is what I call tax neutral. And what I mean by that is, as I've shared already, your real estate taxes remain the same. Income taxes, because you get the income taxes remain the same. Capital gains taxes, very important if you're selling a house or if your children are inheriting the house, all remains the same. As a seller, you keep the $250,000 capital gains tax exemption on your primary. As after passing on, this trust is includable in your estate. Therefore, the children, the heirs, will receive what's called a step up in the basis, which means they inherit it at fair market value and they can sell it without capital gains taxes. Okay, so it is tax neutral, doesn't increase taxes, doesn't decrease taxes. And finally, with all that said about an irrevocable trust, New York does have a law that says it is entirely revocable. The catch is everybody has to agree. Okay, everybody involved has to agree. So it is doable if necessary. Hands down, the irrevocable asset protection trust is the best tool that we have to shelter assets. The contingencies that are built in, the tax benefits that are built in, the control, the flexibility, the security, it's the best tool we have. All right. Now, moving on. And the best way to protect your pot of gold. All right. Now, I've had clients say, I'm just going to give it to my kids. You know, it's 50 grand, it's 100 grand, it's my house. I'm just going to give it to my kids. They're going to inherit it anyway. Bad idea. Okay. You do that with some money. You can certainly do that with some money. I'm not saying you can't, but you don't do that with the real estate ever. And you don't do it with the bulk of the cash unless if it's a part of a master plan, unless if it's a part of a bigger plan that we're putting together. Okay. Why don't we just give it to the kids? It's because of the D's. Okay. If that child is holding your money and he passes on, if he dies, if that child is holding your money and he becomes ill, has a disease, dementia, where's your money going that he's holding for you? Okay. If that child divorces holding your money, it should be out of it, but I'll tell you right now, that spouse's attorney is going after it and you're going to have to fight for it. So you have to prove that it's separate. That child's holding your money. God forbid there's an addiction. If they run into debt issues and creditors, keeping with the D theme, if they're dishonest, all right? If they're, I've had it happen. You've seen it in the papers. They spend the money, all right? They feel they're entitled to it. They're the caregiver perhaps, and definitely doing a difficult job, but that doesn't mean they're entitled to an early inheritance, if you know what I mean. So you need to make sure you're dealing with the right kids when it's appropriate to do this. And again, finally, to keep with the D, if you transfer the house, for example, or the capital or stock to children outright, and then they sell the property or the stock later, they're going to get nailed with the capital gains taxes. They're not going to get that step up in basis that I was talking about that you do get with the irrevocable trust. All right. So if it's a part of a master plan as far as how to shelter assets and access assets to pay for care, et cetera, then yes, you get good kids involved, but it is not an alternative to an irrevocable trust. All right. So that's how the trust works. It is, again, the most important tool that we have. Another very, very critical tool, it's what's called the power of attorney. As I shared before, talking about guardianship. If there is a loss of capacity and there is no power of attorney or it's insufficient, then the family will be thrust into that guardianship proceeding. And the cost and the delays and the tension and the stress, all things you want to avoid, okay? Power of attorney is worth its weight in gold. I sometimes say it's the most important document there is. It's where you can appoint somebody to handle your legal and financial matters if you lose capacity, okay? Now I say, if it doesn't exist, you can be up the creek, or if you have it, but it's insufficient. What does that mean? If you go to a website and purchase a power of attorney form from them, if you go to your real estate attorney, if you go to your son-in-law that's a financial advisor, if you get it from a book at the library, it is not going to be perhaps the most updated form, and it is not going to contain all of the needed comprehensive language that deals with aging and elder care and asset protection and income protection. I sit with clients every single week, and at least once a week, there is a client all happy they have a power of attorney, so they don't have to pay for a new one, which is fine in what we do if it's a good one. But when we get it and review it, it's missing the asset protection language. It wasn't signed properly. It's missing the income protection language. So you have a power of attorney, you think you're good, but you're not. All right. You need to have it done by somebody like us so that it has all of the right powers built into it. Now, the power of attorney, the way it should be, is a New York statutory durable form. New York State has been a little complicated with our powers of attorney laws. They've changed it over the years. The last major change was 2009. They changed it again in 2010, and that's the form we're currently using for now. There is a law that it was signed back in December, changing the power of attorney form once again in June of this month. So only 3 months away, the power of attorney form will take a new shape. It is meant to be simpler. It is meant to have teeth, meaning there's ramifications if a bank doesn't follow a power of attorney. If they don't listen to the power of attorney agent, they may be liable for attorney fees to make them listen. So there is a new form coming out in 3 months. However, for the time being, the current power of attorney has a gift rider attached to it. That is where the asset protection language is built into it. That is where the income protection language is built. You have to have that gift rider. In addition, and I say for now because the gift rider is not a part of the new form, modifications. In the current power of attorney, you've got your main form and you got your gift rider. Both halves have a section for modifications. All right, those sections must be blown out. You have to include the kitchen sink, if you will, to make sure we have all of the appropriate possible issues covered should something occur down the road. It has to be executed properly. Again, the new one's supposed to be simpler, but for the time being, witnessing, notarizing, agent have to sign, principal signing it has to initial in certain areas, the right areas. Make sure you pick the right agent, okay? Sometimes we'll pick an agent that's trustworthy, but he's not disciplined, he's not responsible. He doesn't pay the bills. So you want somebody that is responsible, you want somebody that's diligent, all right? Somebody that you can communicate with. Now, what we're telling clients is sign the current power of attorney. And when we do different levels of work with our clients, we will include the new power of attorney when it comes out in June. Give us a couple of months to figure out the right language, the right additions, and then we'll sign the new one, included as of the fee that we're paying and we're engaged for now, okay? So irrevocable trust, durable, modified power of attorney, worth its weight in gold. So with all that said, and with these risks and these tools that are available to us, when should I protect my assets or my pot of gold? Got to get one more in there. The answer is now, all right? The reality is that if you are mid-60s or older, the time is now to get this done. I've done this type of work, this asset protection work for a client who is 98. They made it, all right? But not all of us are going to get that far without some type of issue, some type of illness, some type of need. So the idea is, as I shared in the very beginning, get the asset protection done before, in advance, and the time frame is 5 years. That is the maximum look back period when it comes to Medicaid. So you want your assets protected, you want to go live your life, and then after 5 years, if you need Medicaid, you're covered, okay? So get it done. Mid-60s, the way I like to say it is when you get your Medicare card, you need to get what we call an elder care protection plan, all right? When we are doing asset protection work for a family or an individual, the elder care protection plan is the service. It's going to be your will, very comprehensive will, the appropriate power of attorney we've spoken about, including the update in a couple of months, healthcare proxy, living will, irrevocable trust, deed to get your home into your trust. That's the basics. Those are the documents, all right? In addition, it's all the advice as far as funding. When we do this type of plan, we stay on board for a period of 12 months. That's how we help our families. We don't just do the documents and walk away. There is a 12-month engagement, if you will. Questions, we'll have the answers. If the bank has an issue, we'll help. If you want to change your documents, there's no additional cost. We offer an annual meeting with the family, with the trustee. Make sure the trustee is operating the trust properly and not doing something improper by accident, okay? Make sure the power of attorney understands what's it for. In addition, when we do this work, we're very unique in the way that we do it. And I say that humbly because I'm honored that and blessed to help the families that we can help, because we look at everything in a very holistic manner. Let me jump to it. We will help a family on the three different fronts, the three different domains that we face with aging needs. It's going to be the legal domain, it's going to be the financial domain, and it's going to be the care domain. When we start helping a family with this elder care protection plan, and if Medicaid is down the road, it's what we call a life care plan, we will address all three domains, the legal, the financial, and the care. The legal domain has a singular goal. Let's protect those assets. The financial concern is, how do we get Medicaid to pay for future care? When it's an elder care protection plan, we don't need the care just yet, but we need the mechanisms and the know-how in place. And when care is needed for our loved one, how do we make sure they get the best care possible? The way we do that is we have what we call elder care coordinators on staff. I've got 17 folks behind me, and all we do is elder care work. So the attorneys focus on the asset protection, the attorneys focus on the Medicaid work, but my advocates, all right, geriatric social workers with dozens of years of experience, help the families navigate the long-term care system. They help the family with peace of mind. They help the family get the best care possible for their loved one, all right? So this is what we do, and this is how we do it. We're here to help. If you have any questions, please feel free to give a call. I'm going to answer questions now if there are any. So if you have questions, we still have a little bit more time. Go to the Q&A box and type your question. I'll be happy to answer it. You can call the office directly, 631-424-2800, or email me direct. This is my email, Brian, BRIAN, @Tully, TULLY, elderlaw.com. All right. So let's see what questions we got, folks. And again, thank you for joining us. All right. Is community-based Medicaid still available? The answer is yes. I will be talking in more depth about this in 2 weeks, but to answer your question with a little more depth, community Medicaid isn't going away. What they're going to be doing in the near future is making it harder to get. So what we're telling folks from the mountaintops is, get your asset protection done. And if you have those care needs that require Medicaid services, those long-term care ADL needs, then get the application in before the law changes. We are hopeful that July 1st will be the implementation date, okay, or further. Now, what that means is, if there's a long-term care need, you still have time to protect. We still have time to prepare a Medicaid application and file it before the implementation date. Therefore, there will be no look-back period. There will be no penalties for home care, all right? Very important issue. Again, in 2 weeks, I'll cover that with more depth. Question about the power of attorney. Oh, we got more chats here. Hold on. All right, one moment here. I'm sorry. Any pitfalls to transfer on death titling of accounts? Good question. So it's a beneficiary, a TOD, or transfer on death, or ITF in trust for, all the same things. They're all beneficiaries. The only pitfall, or what I should, let me phrase it this way, what that does is it avoids probate. Okay. So if you pass away without ever needing long-term care, your goal is avoiding probate, and a TOD account will do that. Okay. You want to make sure, again, you're picking the right people. You want to make sure they're still alive before you go. The downfall, the pitfall, as I see it, is if it's a significant account, you want it protected. Okay. You want it protected before that 5-year look back, so you can get that 5-year look back started. Another concern with a TOD beneficiary is there's no access. That may be the desired result, but without access, they can't help you pay bills. They're just there to inherit, all right, after you pass on. Hopefully that answers. Can you talk a little bit about protection plans moving forward when the Medicaid laws change? So, and thank you for that question. I touched upon it briefly a moment ago, and I'll do it again. But with more depth, come back in 2 weeks or check one of our webinars on our website. Again, tullyelderlaw.com, and what you're looking at is the video tab, and find webinars. So the way it works right now is the new law for community Medicaid is not yet implemented. It is slated to start April 1st. We're expecting that to be postponed to July 1st, okay? Now, assuming that gets postponed to July 1st, and the reason behind that, by the way, it's not just New York State and that they can't get their act together. It's because of the federal national emergency with the pandemic. They're not able to implement it because that's still ongoing, all right? If that national emergency comes to an end on the federal level, then New York can implement this change on the Medicaid program. Again, expecting July 1st. Assuming that does in fact happen, we will have March, April, May, and June to protect assets and file a community-based Medicaid application for home care before July 1st. So there's going to be a run here because everybody and their sister has been applying because they want to get in before the look back begins. They want to protect their assets before they have to pay penalties and pay for their own care. So it's still available. If there's a need, I strongly suggest that you reach out to us and get the ball rolling, okay? How often does a court-appointed guardian see a client? Good question. It's supposed to be, I believe it's every 6 months they're supposed to be in touch. Good guardians are more involved. Guardians that are less involved are doing the minimum. I have not been involved with guardianship practice for a number of years personally, so I don't know that exact answer. I have attorneys, of course, that work for me that do. So we can certainly get that answer for you, but they're meant to be involved and in touch at least annually. And I think it's more than that. With the 5-year look back period, hello, Mary, how are you? Upon the enrollee's passing, will the beneficiaries be able to file their claim to the property? So, good question. When we're setting up an asset protection plan for Medicaid down the road, we will have an irrevocable trust in place, and that irrevocable trust will name beneficiaries, okay? And those beneficiaries will inherit pursuant to the trust after their loved one passes on, after their parent passes on. So yes, they will inherit that. Secondly, IRA accounts and qualified money accounts are exempt from Medicaid eligibility asset calculations. So those beneficiaries will fill out a claim form and they will get that. Thirdly, when an applicant is applying, in our office anyway, we usually have one bank account out there, somewhere between $5,000 and $10,000 with a joint owner. As long as that's done, then when the parent eventually does pass, that joint owner will inherit the balance of that account. So the short answer is yes, Mary, they will inherit. All right. Well, that's it, folks. Those are the questions. Let me wait. Maybe we have more here. Okay, we got them. Good. I want to make sure I got them. I got them. Thank you, folks. It really was a pleasure. We'll see you again in 2 weeks to talk about a Medicaid update and hopefully confirmation as far as eligibility and what we can still do. All right. Thank you again and take care.